The prosecution of Kizza Besigye in the General Court-Martial has raised many questions about the court's powers, especially after it deviated from the universal norms and safeguards of a fair trial in its sentencing of the former full-time presidential candidate's lawyer, Aon Kiza. Besigye's lead counsel Martha Karua argued that such actions are not sacrosanct in the dispensation of justice.
Aon Kiza should not have been stopped from coming in. I myself was stopped from coming in and other lawyers on the 10th. We went to the back. We were then invited. But unlike me, Aon Kiza is an advocate of the High Court of Uganda. He is known by the orderlies. So it looks like there was an intention to actually assault him. And we come here respectfully, we address the court and we leave. And that's all that we need. How is it going to affect the two gentlemen on the dock when one of their lawyers is not there? May we respectfully ask for time to withdraw and confer with them so that we may now know what to do without one of us. Because each one of these lawyers has a specific task. The matter before you is the matter of life and death. That is why it has so many lawyers.
While appearing before the same court on December 10th, Aon Kiza also attempted to persuade the presiding judge, Brigadier General Robert Freeman Mugabe, that the principle of freedom from self-incrimination and the right to a fair trial is provided for under Article 44 of the Constitution and international human rights law.
They tell me, you are not a member of the court. You are not a member of the court. You advise the court and the court rules.
Listen, my advice to this court is final.
No, it is not. It is not.
It binds you.
No. You are not a member of court. He is not a member of court.
Can you first read the section 169 of the
Read it.
UPDF Act?
Read it.
And section 212.
Read it. Read it.
You read that, I'm directing you.
No, you can't direct me. You are not court.
That was only a matter of time before the army court could turn him in too. But the military courts and tribunals have the competence and impartiality exhibited by other courts of judicature. Section 81 of the UPDF Act establishes the General Court-Martial and is part of the army. It is both original and appellate jurisdiction over all offences, and persons under this act consists of a chairman, not below the rank of a lieutenant colonel, 2 senior officers, 2 junior officers, a political commencer, and 1 non-commissioned officer, all of whom are appointed by the High Command for 1 year renewable term. It is not mandatory to have professional lawyers as it is with civil courts. It may sit in any place in Uganda, has 1 appeal division should a party like Aon Kiza not be satisfied with the judgment of the first instance court. Established under the 1995 Constitution of Uganda, under Article 126, which states that judicial power comes from the people. They are part of the judiciary and are headed by the Chief Justice, the 4th most important personality in the country after the President, Vice President, and the Speaker of Parliament. Only employ advocates who have completed postgraduate diploma at the Law Development Center, LDC, and have become judicial officers at different ranks of magistrates, registrars, judges, or justices, unlike the Army Court. Have established courtrooms where the judicial officers sit and conduct their court businesses. The judiciary's role is to oversee justice in the country and to promote the rule of law and order, independent and not subject to the control or direction of any person or authority. Consists of the Supreme Court at Apex, a Court of Appeal, Constitutional Court, the High Court, and the Magistrates Court. Have assessors, as provided in Section 3 of the Trial on Indictments Act, and like in the court-martial. The burden of proof does not shift to the accused, and it is entirely the prosecution to prove the case against the suspect beyond a reasonable doubt. Clear definition of the offence committed and all its ingredients are laid out under specific laws, which may not strictly apply under the General Court-Martial. The late Eli Tumwine, as then head of the General Court-Martial, often detained lawyers possessed with the temerity to question his flawed application of the rules of evidence. It's against this backdrop that several stakeholders Others have likened the military court to a kangaroo court which lacks independent oversight and may be used to pursue personal vendettas. Lydia Felly Akullu, NTV.
Chairman, we are praying for 1 week from now.